Ladies and gentlemen, welcome to lawcaseuk.com, where today I'm going to be analysing the House of Lords decision in the 2001 case of Crown against A, number 2. It's a case that involves the admissibility, or otherwise, of the previous sexual history of a complainant who alleges that the defendant has committed a sexual offence against them. Now, specifically, the case required the Lords to evaluate the regime under Section 41 of the Youth Justice and Criminal Evidence Act and to interpret that in the light of the defendant's right to a fair trial under Article 6 of the ECHR. So as much as it gives us insight into the admissibility of previous sexual history, it's going to look at how the court deals with that aspect when it comes into competition with the Article 6 right to a fair trial. Now, in terms of what's going on vis-à-vis the litigation itself at the House of Lords stage, what has happened is that the question of admissibility of the previous sexual history evidence has been raised as a preliminary matter at a preparatory hearing in a Crown Court trial. And the judge has given a ruling on the admissibility or otherwise of the evidence. That ruling was appealed to the Court of Appeal and was then in due course appealed to the House of Lords. So it's a slightly different case to many that we look at because there has been no conviction. We're not judging whether conviction's been safe. Indeed, there's not yet been a trial. We're looking at the appeal courts considering a ruling made by the judge at first instance as a preliminary matter. So, before we get to the specific facts of the case, let me just reiterate some of the stuff that you might already know about these type of offences. Of course, it's widely known that due to their often private context, sexual offences can often be difficult to prove, particularly when one takes into account the burden and standard in particular of proof in a criminal trial. Often, when the assailant is already known to the complainant and the issue revolves around consent in the case, the evidence can boil down to the complainant's word against that of the defendant. And this is reflected in a statement made by Lord Hope in the case of A, where he said, "It is notorious that proof that the complainant did not consent to an admitted act of sexual intercourse raises difficult questions which, in the typical case, resolve themselves into issues of credibility." Now, in such cases, the question that arises, therefore, is whether the complainant's sexual history has any probative value to the issues that the court is considering. Another way to ask this is to ask the question of whether that sexual history is relevant to anything in the case, and then this, of course, leads to the issue of, well, relevant to what? Of course, that must be a particular issue, and if we take the allegation of rape that was made in the case of A, then the relevant consideration becomes one of consent, or if we look at it specifically, in the rape context, part of the actus reus is, of course, an absence of consent, and it's for the Crown to prove that. So, in the case of A, the certified question that the Lords had to consider was this: may a sexual relationship between a defendant and a complainant be relevant to the issue of consent so as to render its exclusion under Section 41 of the Youth Justice and Criminal Evidence Act 1999 a contravention of the defendant's right to a fair trial? So, in effect, as I've already suggested, the case involved the court striking a balance between the right of the complainant to avoid unnecessary humiliation and distress, and also the right of the defendant to have a fair trial. And as well as those two competing individual interests, we can look at it in a wider context, and as Lord Steyn recognised in his judgment, the notion of what constitutes a fair trial in this particular context involves what he called a familiar triangulation of interest of the accused, the victim, and society. And society is important here as part of the justification for the statutory regime under Section 41 is that society itself has an interest in protecting complainants, as it has an interest in not discouraging victims of sexual offences from reporting the crime and supporting a prosecution in that respect. So society, as well as the defendant, as well as the complainant, has an interest here. Now, Lord Steyne, like some of the other judges, does look at the historical context for the admission of previous sexual history evidence, and he identifies that the criminal law has been slow to adapt to the changing attitudes of society towards the independence and autonomy of women, in particular in relation to sexual matters. As he points out, in particular, the law needed to resolve the discriminatory stereotypes which existed around women's behaviour and the way that the courts viewed them and the admissibility evidence in relation to that. And in terms of identifying these unacceptable stereotypes, Lord Steyne, in the case of A, referred to the Canadian case of the Crown against Seaboyer, which is a 1991 case, where the court there is assessing its own rape shield legislation. And what we have here is that the court in Seaboyer refer to what are known as twin myths, these discredited myths, two of them really, which one, unchaste women were more likely to consent to intercourse, and in any event, unchaste women were less worthy of belief. And indeed, counsel for the Secretary of State, who of course intervened in the case of A because of the human rights aspect, counsel indicated that Section 41 of the Youth Justice and Criminal Evidence Act was passed with Seaboyer and those twin myths in mind. Now, to give you quite a bit of background context, and it is reviewed by the Lords in the case, Section 41 was passed following criticism of the previous regime, which existed under Section 2 of the Sexual Offences Amendment Act 1976. This was the first so-called rape shield, and this provided for the regulation of sexual history evidence, but only in relation to rape cases and only when that evidence related to activity between the complainant and third parties, i.e. not the person charged with the offence. Now, in relation to evidence with third parties, such evidence could only be admitted if leave of the court was obtained, and leave was only to be given for that questioning or adducing of the evidence if the judge was satisfied that it would be unfair to the defendant to refuse the evidence. It's interesting perhaps to see the word fair being used in 1976. Obviously that's a long time before we start talking about fair trial under the Human Rights Act of 1998, although of course the common law had for a long time been concerned with fairness of the trial, and also if we look at the 1984 statute that is PACE, under Section 78 it talks about the fairness of the proceedings there. Also of interest, I think, as well as the use of the word fair, is this distinction that the law made at the time between sexual history between the complainant and the defendant and sexual history between the complainant and third parties. The first rape shield was wisely seen as not being a success. It wasn't protecting women from the twin myths that I've identified, and Section 41 was an attempt to create a further rape shield in order to do that. It is certainly a wider rape shield in that it covers more behaviour, and the protections now extend, and it covers more offences. The protections now include any sexual offence, so it's not limited to rape like it was in 1976, and sexual behaviour is wide enough to include activity with the complainant and the defendant, not just with the complainant and third parties. Now, in this regard of changing that distinction, Lord Hope said of the Act that, bear with me, it ends the assumption, widely held hitherto, that the complainant's prior sexual behaviour with the defendant is always relevant and admissible. So it changes that position. But that change was, as Lord Stein described in his judgment, the genesis of the problem before the House. And in fact, Lord Stein draws a distinction between evidence relating to the complainant and other men and that between the complainant and the defendant. And what can only be an obiter comment, he said that the evidence between the complainant and the third parties was dealt with fairly by Section 41 of the Act, and he added that such matters were almost always irrelevant to the issue of consent, although I would say you can contrast this with what happens in a later case involving the footballer Cheddar Evans. So see what happens using A in that case to move the debate forward. But in this context, Lord Stein felt that the exclusion under the statute of sexual history between the complainant and the defendant, that actually posed what he called an acute problem of proportionality. He said that such evidence may be relevant to the issue of consent, and specifically what he said was, what one has been engaged on in the past may influence what choice one makes on a future occasion. Accordingly, a prior relationship between a complainant and accused may sometimes be relevant to what decision was made on a particular occasion. So he does see a particular issue with the statute insofar as it goes to exclude previous sexual history evidence that pertains to the relationship between the defendant and the complainant. Now, with that in mind and quite a long introduction by way of background, let me take a look at the statute itself. It is far from simple. But what it says is that the admission of sexual history evidence requires leave of the court, and leave may not be given unless the evidence falls within one of four gateways under the section. And in addition to falling within the gateway, the judge has to decide that refusal to give leave would render unsafe a conclusion of the jury on any issue. And you can see unsafe is the word used in section 41 in place of the word fair that had been used in the previous rape shield in 1976. Now, skipping through the gateways, the four gateways are, firstly, the issue is not consent. So the issue is not consent. Remember what I said is that to be admissible, it has to be relevant to an issue, i.e. something the defence or the prosecution have to prove. And the first gateway is that issue is not one of consent. And here it could be, say, the mens rea of reasonable belief in consent. The second gateway is the issue is consent, but the sexual history is alleged either to have taken place at or about the same time as the alleged offence, or it is so similar to the offence alleged or to any other sexual behaviour occurring at or about the same time that it should be admitted. And the fourth gateway is that the evidence can be adduced if it's necessary to rebut or explain evidence put forward by the prosecution. That last one is not that controversial. Importantly, though, when we look at those gateways, the statute contains no residual discretion for the judge to grant leave on a general basis, such as the interest of justice. We do see that, for example, in the Criminal Justice Act when it talks about the admission of hearsay, but not here. There are four rigid closed gateways. So let's have a look at the gateway's relevance in the case of A by looking at the facts in the case. Now, the defendant was alleged to have raped the complainant on the 14th of June, and his defence was that she had initiated the consensual intercourse and it was part of a continuing sexual relationship between them. He alleged that the relationship covered 3 weeks before the alleged rape, and the last actual sexual event before the rape happened 7 days before. So there's this gap of 7 days, and he applied to adduce the evidence under section 41 where the issue was one of consent. Now, that's section 41.3, and in the Court of Appeal it was accepted, in part on the basis of concession by the prosecution, that such evidence would be admissible under the first gateway, the non-consent issue gateway, in order to support a reasonable belief in consent defence. So on the arguments in A, that itself wasn't controversial. Now, there are of course difficulties for a jury when they hear evidence for one purpose and another purpose is in play here. But that was not the key concern in this particular House of Lords case. Here, what was important was the ability of the defendant not to adduce evidence under that gateway which the Crown had conceded, but here was to adduce the evidence under the gateways in 41.3 B and C. These similarities, firstly similarities in timing and then a similarity in act. And whether any exclusion of that was prejudicial to a fair trial. And it's this part of the Act that the court is looking at to see if it's compatible with Article 6. Now, of course, what this required the Lords to do was to interpret the statute. And I'm going to concentrate here on Lord Staines' interpretation. And the approach he took was to ask whether in human rights terms the exclusion under section 41 was no more than necessary to achieve this legitimate aim of countering the twin myths that I've identified. Now, when he looked at the statute, looking first at the gateway where there is a link in time between the two incidents, the incident alleged in front of the jury and the previous sexual history incident, he looked at that temporal restriction, the time restriction, and he said that it was so narrow that sexual events that were 1 week before this were excluded. And in this regard, all of their lordships found that the time period alleged by the defendant was too remote to come within the statutory gateway. So this left the similarity of act gateway in subsection 3C. Now, here the court was considering this gateway in an abstract sense, as the defendant himself had not put forward at this stage any particular similarity other than he and the complainant had had consensual sex previously. But when the court look at the wording of the statute, the important aspects of the subsection are that the acts are so similar and that the similarity cannot be explained by coincidence. Now, for those of you that are familiar with similar fact evidence, the court did explore whether the similarity needed to be so strikingly similar, but they decided that it didn't, because if Parliament wanted to use those words, it would have done so. But the test was whether the similarity cannot reasonably be explained by coincidence. Now, looking at both of those, Lord Staines concluded that without anything else, the evidence could not be admitted under either gateway. And in this respect, he characterised the Act as, quote, legislative overkill. And so for him, if the evidence was potentially relevant, the only way to protect the right to a fair trial, using statutory interpretation at least, was to use the interpretative obligation under Section 3 of the Human Rights Act. Because the case occurs quite soon after the entry into force of the Human Rights Act, the lordships are quite keen to demonstrate how this works. And in particular, of course, as we know, the Section 3 places a duty on the court to strive to find a possible interpretation compatible with convention rights. That's as Lord Staines put it. And in doing so, he acknowledged that it will sometimes be necessary to adapt an interpretation which linguistically may appear strained. But what he does, he explains this on the basis that his overriding assumption is that Parliament would not intend to legislate in such a way as to deprive an accused of a fair trial. So, accordingly, for him, subsection 3 of section 41 was to be read, therefore, quote, as if it was subject to the implied provision that evidence or questioning which is required to ensure a fair trial under Article 6 of the Convention should not be treated as inadmissible. And this led Lord Stein to put forward the following test, with which the other judges agreed, and he said this would be the task of trial judges to apply. So he said, the test of admissibility is whether the evidence and questioning in relation to it is nevertheless so relevant to the issue of consent that to exclude it would endanger the fairness of the trial under Article 6 of the Convention. If this test is satisfied, the evidence should not be excluded. Now, by using Section 3, he and the other judges that went down this road avoided declaring the legislation incompatible with the Human Rights Act. And they also avoided really answering the certified question, because instead what they said is this was the matter for the trial judge, and so they remitted the matter back to the judge to consider or reconsider whether to admit the evidence using the test that the Lordships had now handed down to them. And in effect, what we can see there is that what the House of Lords has done is they've in effect created that residual general judicial discretion based on fairness. We could call it interest of justice, but here fairness, which was left out by Parliament when they drafted the statute. So in this case, that discretion was identified. It was identified using Section 3 to read down the provisions in Section 41, and therefore the matter was sent back down to the trial judge to reconsider in the light of this revised interpretation. So that is the case of A, ladies and gentlemen.